Some court cases are just about legal details, but then there are the ones that shape the very soul of a nation. And that's exactly what we're diving into today. We're talking about one of the most important judgments in Indian history, a case that tried to solve a social puzzle that had, quite literally, set the country on fire. Indra Sawhney versus the Union of India. Wow. I mean, just to get a sense of how heavy this case was, you really have to start right there, with the words of one of the judges. This wasn't some abstract legal argument happening in a quiet courtroom. No, this was a full-blown national crisis, born from decades of inequality, and it was boiling over into these tragic, desperate acts right on the streets. So you have to ask, what was the spark? What lit this fire? Well, it all goes back to 1990. The government decided it was time to implement the recommendations from something called the Mandal Commission report. And what they did was issue an order reserving 27% of jobs in central government for what they called socially and educationally backward classes. And just that one decision, boy, it unleashed a storm of protests and counter-protests that absolutely shook the nation to its core. So picture this. Before the lawyers could even get up and make their arguments, the streets were already in chaos. The Supreme Court wasn't just being asked to, interpret some dry piece of law. They were being asked to calm a nation that was truly on fire. And if you want to know just how bad it was, you don't have to look any further than the court's own judgment. It paints a really grim picture. The country was just torn apart by what they called unabated pro as well as anti-reservation agitations. Think about that. Normal life, it was paralyzed. The judges themselves called it an orgy of violence that led to people losing their lives and public property being destroyed. And it's from that chaos, that the Supreme Court had to try and forge some kind of constitutional solution. All right, so the court is now faced with this massive constitutional puzzle. And right at the heart of it all was a really simple but incredibly powerful question about what equality even means. And this is where it gets really tricky. You've got this central conflict in the Constitution itself. On one hand, you have Article 16.1. It basically guarantees everyone equality of opportunity when it comes to government jobs. Simple enough, right? But then, on the other hand, you have Article 16.4, which says the government can make special provisions. Yep, reservations, for what it calls any backward class of citizens. So you can see how these two ideas seem to be pulling in completely opposite directions.
So this leads to the big question, the one the court absolutely had to answer. Is that special provision, Article 16.4, just an exception to the main rule of equality? I mean, is affirmative action just fundamentally at odds with the whole idea of equal opportunity for all?
And the court's answer here was, honestly, it was profound. They said no. Reservation isn't an exception to equality. It's an illustration of it. To get this, you have to understand the two types of equality they were talking about. There's formal equality. That's just treating everyone exactly the same. Like giving everyone the same sized box to stand on to see over a fence. But then there's substantive equality, which is what the court was really aiming for. And that's about giving people what they actually need to have the same opportunity. So you give the shortest person the tallest box. Reservation, the court argued, was that taller box. It's a tool to achieve real, meaningful equality, not just equality on paper. Okay, so with that foundational principle locked in, the court was finally ready. It was time to deliver its landmark verdict, an answer that was designed to bring some order back to all that chaos. And then, on November 16th, 1992, the verdict dropped. The Supreme Court upheld the 27% reservation for other backward classes. But, and listen, this is a huge but, it wasn't just a simple yes. It wasn't a blank check. The court laid down a really clear set of rules that would basically govern all reservation policies in India from that moment on. And really, this is what makes the judgment so historic. The court didn't just give a thumbs up or thumbs down. It created a whole framework that would last for decades. So let's break down the three biggest rules it established. First up, and this is probably the most famous one, the court set a 50% ceiling. What that means is that total reservations for all groups combined could not go over half of all available jobs. The court's thinking here was that this was a reasonable limit. It was about striking a balance, right? Balancing the goal of helping disadvantaged groups with the need to keep the government running efficiently and, of course, the rights of the other 50% of the population. All right, the second big thing the court came up with was this concept of the creamy layer. It was a major innovation. The court basically said, look, not everyone inside a so-called backward class is equally disadvantaged, right? Over time, some members have become socially and economically advanced. So what did they do? The court mandated that this creamy layer must be excluded from getting reservation benefits. And the logic is pretty straightforward, right? The whole point of reservation is to help the people who are genuinely disadvantaged, not the folks who've already overcome those social hurdles. This was a really crucial move to make sure affirmative action was actually hitting its target. And rule number 3? This was a pretty big limitation. The court said that reservations would only apply when you first get a job, getting your foot in the door of public service. It would not apply to promotions once you're already in. Again, you can see them trying to balance all these different competing interests.
Okay, but there was another piece to this puzzle. The government had also put out a second order. This one created a separate 10% quota, but this time for the economically poor, people who weren't covered by any other reservation. So what did the court do with that one?
They were swift and they were decisive. The court struck it down. Unconstitutional. And their reasoning here is so important. They said the whole constitutional justification for reservation was to fix historical, social injustice, not just economic problems. In the court's view, being economically backward wasn't the same thing as being socially backward. So creating a quota based on money alone, that was just outside what the Constitution allowed for at that time. So the verdict was in, the rules were set, but the Supreme Court wasn't done. They didn't just lay down the law and walk away. They also laid out a clear path forward for the government to make sure this judgment actually got put into practice. And this is where you see how practical the verdict really was. The court told the government, first, you need to set up a permanent body whose job is to review who should be on these reservation lists and who shouldn't. Second, they ordered them to come up with specific, clear criteria to identify that creamy layer we talked about. And maybe most important of all, they said the 27% reservation could only be implemented after that creamy layer was identified and officially excluded. And just like that, the Indra Sawhney judgment, which most people know as the Mandal Case, became the bedrock. It's the foundational legal text, the definitive framework that, to this very day, shapes India's really complex and, let's be honest, often contentious reservation policy. It definitely didn't end the debate, not by a long shot, but it gave that debate a clear set of constitutional rules to follow. The court in 1992 gave an answer for its time. It created this framework that tried to balance justice, equality, and efficiency. But in doing so, it also left us with a question that every single generation really has to answer for itself. In our society, which is constantly changing, what does true equality of opportunity actually look like today?